Good morning, everyone.
Good morning.
We'll just wait another minute and then we'll get started.
Morning, Adona.
Good morning. I'm just going to mute everyone, but if you have questions, just please unmute yourself. Before we get started, how are you guys doing with all the new changes?
Nothing's really impacted me yet.
That's good.
There's really been no hurdles to overcome. It's been a natural conversation, and I think things will take care of themselves.
Absolutely. Just going to pull my screen and then we'll get started. Can you all see my screen?
Yes, we can see it.
So with all the new changes, of course, we just have to make sure we keep you guys up to date with the rental compliance. We've seen so many different issues come up, and we just want to make sure that you guys are, you have to remember we're licensed, so we come with the law. If a owner does not want to comply, you must release that list. Don't, let me just mute everybody. Just please remember, if you're not asking questions, just mute yourself because it will make it so much easier. Thank you. All right, so here is our agenda. So we're just going to go over the Fair Housing Act for New Jersey Fair Housing Laws, the Code of Ethics. Then Section 2 will be the lead paint disclosure, the municipality list. Section 3 is the flood risk notice, and Section 4, compliance in dot loop. So let's just get started. All right. It's going to be a lot of reading, but sometimes you guys just need to hear it out loud. If I send you this PowerPoint, you would probably not look at it. It's boring. So the Fair Housing Act protects home buyers from discriminations as they get a mortgage, rent a home, buy a home, seeking housing assistance, or participate in other housing-related activities. The Fair Housing Act prevents discrimination based on race, color, sex, national origin, religion, disability, or familial status. This is the NAR Code of Ethics. On November 13, 2020, NAR's Board of Directors strengthened realtors' commitment to upholding fair housing ideals, approving a series of recommendations from NAR's Professional Standard Committee that extend the application of Article 10 of the Code of Ethics to discriminatory speech and conduct outside of members' real estate practices. If you're in my office, you should have received an email from me a couple days ago. You must complete the 3 Code of Ethics that's due December 31st. Okay, so I know our CE classes are due next April 30th, 2025. The Code of Ethics it's every 3 years. So you must have it done by December 31st, 2024. It's free. Please make sure that you register for it. If you're not in my office, please reach out to your manager. They should also have that email. And everyone don't wait till end of December trying to scramble and do this. Okay, so this is a great opportunity to just get it done, and then you'll be done for the next 3 years. Any questions on that? The Federal Fair Housing Act, what does it cover? Obviously, race or color, national origin, religion, sex, familiar status, as well as disability. You will have owners that might not want to comply. You have to comply. So therefore, whether you've been working with that particular client for many, many years and they give you a lot of business and you want to do what they say, you can't. So please make sure you always remember you come with the law. It is illegal to discriminate against persons belonging to any of the legally protected classes in any of the following situations. So refusal to rent or sell housing to any person who is legally protected by the Act, setting different terms, conditions, or privileges for a sale or rental to any person who is legally protected by the Act, providing different housing services or facilities to any person who is legally protected by the act, falsely denying that housing is available for inspection, sale, or rental to any person who is legally protected by the act. That's an example of like a Section 8, right? So if somebody's texting you saying, hey, I want to see this apartment, and you don't reply, that's going to fall into this category. Refusal to make reasonable accommodations in rules or services for a disabled person that has been deemed necessary by a physician. Refusal to allow a disabled person to make reasonable accommodation to his or her dwelling. Threatening or interfering with anyone making a fair housing complaint. So federal fair housing laws prohibits discrimination in housing to 6 protected classes. However, New Jersey fair housing laws extend beyond the 6 protected classes, which I'll show you in the next couple of slides. Please remember, if you guys have any questions while I'm going through, this is the time to ask questions. I'm going to actually just ask my team to take attendance. So you guys will receive a survey. It's not yet right or wrong answers. We just want to see where we stand, where we need to focus on helping you guys learn this material. All right. In New Jersey, it is illegal to discriminate against a prospective or current buyer or tenant because of race, creed, color, national origin, sex, gender identity, or expression, marital status, civil union status, affectional or sexual orientation, familiar status, pregnancy or breastfeeding, actual or perceived physical or mental disability, ancestry, nationality, domestic partner status, source of lawful income used for mortgage or rental payments, or liability for service in the armed forces of the United States. It is also illegal to place any advertisement or make any statements or express directly or indirectly any limitations to offer housing or real estate based on any of these characteristics. So you can see in New Jersey, it goes way beyond the 6 protected classes. If you are attending, once Marnelli joins in, she's going to take attendance. Please write your name. We'll email you guys these slides so you can use them. So this is landlord must provide reasonable accommodation to disabled tenants. We've seen so many lawsuits when it comes to this. So guys, please make sure you are educating the owners. I know it used to be so easy just taking a rental and it's quick money. You can do few a week, a month. Make sure that your owners are educated. What you give out to them, that's how they're gonna react to it. So make sure you let them know. In New Jersey, it is illegal for a landlord to refuse to make reasonable accommodations with regards to the rules, policies, practices, or services of a given property. When such accommodations will give someone with a disability an equal opportunity to use and enjoy the property. This includes reasonable physical modification of a premises that may be necessary to ensure that a tenant with a disability is able to fully enjoy the premises. Not all accommodations requested by the tenants may be reasonable. Those accommodations is determined on case-by-case basis, and a requested accommodation may be so excessive that it is unreasonable. On the opposite side of the spectrum, determining whether an accommodation is sufficient to provide equivalent use of enjoyment as that enjoyment met by residents without disabilities is also assessed on a case-by-case. Giuseppe, you have a question?
Good morning. Is
Good
this for New
morning.
Jersey only?
It is only for New Jersey.
Thank you very much.
You're very welcome. Let me just see if someone has a question. Any questions so far? So, let me go to the next slide. Here are some examples. If a tenant with a disability has special needs that require making an exception to an existing policy, such as allowing a seeing eye dog in a building with a no pet policy, the animal must be allowed. And an additional fee cannot be charged as pet rent or as an additional security deposit because assistance and service animals are not considered pets. They are reasonable accommodation necessary for tenants with disabilities to enjoy the premises to the same degree as tenants without disabilities. This is very, very important because I know a lot of owners, they don't want pets and they make it very difficult. So just remember, guys, that if you have somebody that has I'm sorry, I'm like losing the service animal, you cannot charge extra rent per month or security. For example, if one of your tenants become disabled in an accident and needs to use a wheelchair, you may have to take steps to provide or permit reasonable accommodation or modification. The tenant may request that you add a wheelchair ramp to the building so they can enter, use, and enjoy the building to the same degree as tenants without disabilities. If the ramp is to allow access to public space such as the office, the pool, the gym, or the garage, your duty to provide reasonable accommodation would likely give rise to an obligation to add a ramp. Failure to install the ramp could expose you to liability under federal and state law because in this example, the ramp is a public space. You may be responsible for the cost to construct and install the ramp. The same is not true with respect to access to the unit itself or the inside of the unit. So just keep in mind, if a tenant is requesting accommodation or modification inside their unit, the tenant can do that. They will just, when they move out, they would have to bring the property back to the way it was. Okay. As a landlord, you may not charge a tenant require reasonable modification or additional fee for implementing the reasonable modification, nor can you require a larger security deposit based on the tenant's requested modification or medical equipment. For example, if a tenant requires that a wheelchair ramp may be installed in his or her apartment, you may send him or her an invoice for the cost of installation, or the tenant may arrange for a construction of the landlord-approved ramp at the tenant's own expense. But you cannot charge a fee over and above the cost of installation, nor can you require a larger security deposit based on the modification or in the above example, wear and tear from the tenant using a wheelchair in the apartment. So if somebody has a pet and, they have the right documentation that that's a service animal, your landlord cannot charge them rent, additional rent, or security deposit. I've heard from some of you in the past asking me, can the landlord charge more? Now you know you cannot. The Fair Haven of Fair Housing
I just
Stimulation.
want to add something. I had a landlord
Yes.
prior to working with me charge a $500 pet fee for emotional security pet. His legal bills are to the tune of $15,000 so far.
How much was the fee?
$500.
Okay, so, the fact that they have us taking 3 fair housing credits every 3 years, it just shows you how serious this is. All right, at this time, I'm just gonna ask for you all to just type in your name on the chat, first name, last name, please. Marnelli's gonna just take attendance so that we can email you the survey at the end. So if you guys can just take a minute, that would be great. So if you guys go to this website, the Fair Haven, they have the stimulation where you can actually just see how this works out. You get a better understanding. And it just gives you stimulation training about discrimination in the home buying process. So again, you'll receive these slides, so feel free to look at it later.
Donna,
Yes.
I have a question. Quick question. Are these
Hold on one second. Let me just mute everybody for a second. All right, Audrey, you can unmute yourself, please.
okay? Are there exceptions for certain multifamily properties and also for if the landlords actually occupy the property?
We come with the law. So if the owner did not choose a real estate agent and they rented their own property and they live in one unit, then there is exceptions. If they pick you to represent them, then no, they have to abide by the law.
Why I ask is because I know there are people who are allergic to animals, seriously allergic to animals. And that's one reason why some people, I mean, there are those people who don't like animals, that's different. But if an owner occupies the property and they're allergic to animals, what is that? How do
So
they?
this is case by case as well, right? So if they have the proper documentation saying, hey, they're severely allergic, then that could apply to it. But again, it's case by case. So it's hard to like give you a definite answer until you come across that situation.
Okay.
Okay. I'm sorry, I went too far. Give me 1 second. All right, so the buyer's override to fair housing. Realtors are committed to abiding by fair housing laws and the code of ethics. So again, this touched base on the 3 credits that I told you guys. So please make sure you register for that class. I know many of you already emailed me saying that you already taken this, so that's great. If you have not, just go to NAR website, sign in, register, it's free. And if you want the link, just again, reach out to your manager, they have it. At home with diversity, learn to work effectively and within today's diverse real estate market. The At Home with Diversity certification teaches you on how to conduct your business with sensitivity to all client profiles and build a business to successfully serve them. So they do have this. If you guys ever wanted to register, just go on our website or your board, and they will have something that you can take. And I'm sure it's going to cost money, and you have to pay the yearly dues to have this on your signature. So if you are interested, this would be something that you guys can also take. Now we're going to go into the lead-based paint certification disclosure, contract of sale and leases. Reminder that lead paint disclosures for all sales and rentals are required for all properties built prior to 1978, must be completely filled out. The fine is now $11,000. So for each line that you miss, it's about 2,000. But then after, if you have like 2 or 3 things missing, it'll just go to 11,000. So make sure you fill those out completely. On purchases, I actually had a transaction that this became an issue where the seller never, I'm sorry, the buyer's agent never checked marked that the buyer has an opportunity to do a 10-day inspection, or that they waived to do an inspection. Now, when they went and the lender requested that that be checked marked, they couldn't close for another 10 days. So just please make sure you complete that before you go to the closing. So that way it doesn't delay a closing. And then same thing for rentals, you must have this document. If it's built prior to 1978, even if it's fully got renovated, if they kept the foundation, that you need the lead paint. And just so you know, E&O insurance does not cover this. So this would be out of pocket to you if you get fined. So here's the lead paint, just to go over it, make sure each line is initialed, check box for each one that applies to it. Make sure they sign it, make sure you sign it, and then the buyer. All rental dwelling units required to be inspected for lead paint within 2 years. The effective date of the law is July 22nd, 2022, or upon tenant turnover, whichever is earlier. This means that the first inspection must take place no later than July 22nd. So I'll send you guys this. You have the links. You can check the municipal listing. Now, I know there are some condos that they already have the certification, so they don't need to do this. That's great. You must call the association, get it in writing that they have the certification. Any questions on the lead paint inspections? There's a few. I know some towns, they say, oh, they're not participating. That means the owner has to hire somebody that's not in town to have this inspected. And if you're representing tenants, please make sure this is part of the transaction. Make sure you get this from the listing agent. Don't bypass it. So this is the flood risk notice. This has been in effect since March 20 of 2024. Whether you represent the landlord or the tenant, we must have this. Let's say you represent the tenant. It is still your responsibility, even if the listing agent does not give you this document, it is your job to make sure you get it. Do not allow your tenant to sign a lease and get into that house without having this document. We've been very strict in compliance with this, so please make sure you have this document. And if you're on the landlord side, I would highly recommend now that if you have the listing, make sure you upload this on the MLS. So that way, if you do forget to send it to them, you already know it was on the MLS. That protects you. But if you are closing the transaction, you want to make sure you have this document signed.
Donna,
Yes.
I have a question. If that is the existing tenant, I mean, do they need to, does the landlord need to provide this flood notice to the existing tenant?
No, this is if you're turnover. If you have a
Oh,
new,
okay.
okay.
Okay, thank you.
Any other questions on this flood risk notice? Guys, I know we keep like saying it over and over again, but we are, I won't say most, but a few of us still don't understand that this is a required document by law. They cannot waive it. This has to be in your documents on .loop.
Can I go back to the lead thing that you were talking about?
Okay,
So I had a rental recently, and the town told the owner that they were not doing this lead test. They had nobody scheduled to do it, and they weren't doing it right now. They had them do the CO. They went out and did the CO inspection, and they told them that their tenants can move in. Now, and even if they paid somebody to do this test, who are they giving this thing to?
you have to provide the certification to the tenant.
The lead information I'm talking.
The lead paint and correct, you would get a certification that this was inspected and you provide it along with the lease.
Yeah, Donna, I would still return it to the town as well, just to cover your bases.
You can
I had
do
the
that
same
The
too.
town they're not taking it though, because they're telling her that they're not doing it because they haven't had themselves set up with that yet. So
Yeah,
I
they
don't know
don't
why
really
the
have a
state is
choice.
making these mandates and the towns are not prepared to do it. It's just ridiculous to me.
It is, but we still need, just because the town is not doing it, it doesn't mean it exempt us, like, oh, okay, they're not doing it, I don't need it. You need it. Make sure you have this. So I'm gonna look at the questions later on. I see it on the chat, so I'm just gonna go on and then towards the end, I'll go back and answer any questions. But yeah, I agree with Glenn, like you should send that to the town as well, especially if they are participating. And then make sure you provide this to the tenant. And the landlord should also have a copy, of course. So this is the residential lease, which has been changed to include, obviously, line 35, the lead-based paint. That inspection must be done. So it's on the lease, guys. So that's how serious it is. So please make sure they're being done. I know we're doing a lot of rentals, and you don't want to miss the opportunity because you will
If he doesn't do it, we're gonna do it and bill him. How's that?
I'm sorry, say that again.
Well, I think you need to.
Oh, let me see. Let me just mute everybody
You
again.
guys tell
Contract of sale also has the lead paint, and you must check mark one or the other if it's applicable or not applicable. So just also make sure that this, obviously, if you're selling the property, you don't have to do a lead paint inspection. Disclosure that property may need lead paint certification on a contract of sale. When an agent is notified that a buyer is purchasing a residential property for the sole purpose of renting, it is best practice to advise the buyer of Senate Bill number 1147 and the lead paint inspection, which will be required on July 22nd, 2022, should they choose to rent the property. So if you're representing a buyer and they're purchasing an investment property that was built prior to 1978, please make sure you let them know. Don't tell them after the fact, like, oh yes, great, you bought the property, now you need to do a lead paint inspection for your tenants. Make sure they are aware of this before they get in contract. Remember, disclose everything.
I have a question about the lead paint.
Yes.
All right, so I have a rental, and now after listening to this meeting, I'm going back to my dot loop to see what I made. I might have made a mistake. Where it says B for the landlord, leaser, records and reports available to the leaser. before we would just check off lesser has no reports records pertaining to lead paint, blah, blah, blah. But now we have to get that lead paint thing, you know, and download that, as you said. Am I checking that block? Am I not checking that block off or
Where it says records and reports available to the lessor, check 1.
yeah.
So you would do, lessor has the following reports or records pertaining to lead paint and or lead paint hazards in the housing. So you would check box number 2, because now you're gonna have to get the inspection done.
All right, but I don't want to be like splitting hairs here. But for example, with mine, I'm having it painted next week. I might have a tenant this week. So I'm not ready to have the lead paint guy that we're paying to come in and do the inspections. So, like you said, have it downloaded, but I'm not going to have it till after I probably have the tenant.
No,
because
yeah, so the lead paint and yes, so you can still check box 2 because you are gonna have the reports.
well, I'm going to have it, but it's just not going to have it when they sign this.
Right.
Is that okay?
That's fine, as long as they have it, you know, sometimes the inspection might not happen until you actually have a lease, right? So, for that, I would still check box 2, still have it, have your owner sign it, so they know they have to
Right.
get this done. And then, once you have the report, then you can provide it to the tenant and the town.
Okay, and one last thing, because my phone died out when you were talking about things about handicapped people and what the landlord has to do. I thought that the tenant has to pay for, the landlord has to allow the tenant to put in the ramp, et cetera, et cetera. But maybe I missed part of what you were saying, but tell me that landlord is responsible for some of those concessions?
No, so the tenant will pay for those accommodations, the landlord just has to approve it. And then if the landlord decides to find somebody who can do it for them, they can, and then charge the tenant, but they cannot charge more than what they were charged. So like, let's say if something costs $500 and, you know, the landlord paid for it, now they're charging the tenant, they can't go and say, oh, I'm charging you $550 for the inconvenience. You know, like you can't charge more than what the actual cost was.
Well, what about, and one last thing, then I'll let this go, I promise. You go in there, most stoves are not handicap accessible, you know, where they have lower knobs and all that. What if they go into the place and they say, well, I need a new stove because I can't reach the knobs? Is the landlord required to buy a new stove, or does the tenant have to buy the stove?
It's case by case, depending what their disability is.
Okay, who decides, like, if I have this discussion and I'm going back and forth, is this to my broker? Do I call the board? Who do I discuss this with to find out what
I would say
have?
first reach out on the broker side, and then we'll decide what it is and who we need to reach out to get the answer.
All right,
Because
thank you.
it's
Very
going to
good.
depend case by case, right? So
All right, thank you.
you're welcome. Any other questions before we move on?
Yes, I have a question. So if
Yeah.
the building has been inspected from a lead inspector and have the certificate of lead-free building, now when I sign the lead-based disclosure, I have to check box
Number 2,
number 2?
where you have the report and then you have the certification that you can show that you don't need anything else besides the certification.
Okay, and this certification is good for 2 years,
Correct.
no matter how much.
No, or
oh,
turnover. You have to have the building inspected every 2 years. Now there is like high-rise buildings, some of them get it exempt where they do this, like it's very costly. Where they can get it exempt. They do a one-time inspection and they get that certification. So they don't have to do the inspection again. But that's like thousands of dollars. If you're gonna do the inspection, it has to be done every 2 years or every tenant turnover. So if you have a tenant that's moving out after a year, you're gonna have to do it again.
okay,
Hi,
got it.
me again.
Yes.
Sorry, but now I'm
That's
looking at
okay.
this whole form totally different than I used to. Okay, number 3, leaser's disclosure. It has, we used to just check off, leaser has no knowledge of lead base paint. This particular property of mine is an 1860s, you know, renovated, I won't say renovated, but it's a Victorian. So obviously it's got lead paint 8 layers back and everybody knows it. You know, it's just the way it is. So here it has, we used to check off, leaser has no knowledge of lead paint, blah, 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 blah. Am I now checking off the top block, known lead lead-based paint.
Yes.
So now it's different than it used to be. I have to check that off because it does have lead paint, because everybody knows it has lead paint.
Yes, so you do have to check box 1.
Okay. Yeah, we got to make that clear to everybody, because we
You
always
have
just,
to explain it, right? So you have a line there to explain what it is.
oh, because the house is older than 1978. Obviously, it's an 1860s Victorian, and then obviously maybe 10 layers back with paint jobs over the years. You're going to have lead paint somewhere.
Right.
Oh, yeah. All right, thank you.
You're welcome.
Hi, can I just check on that?
Yes.
I guess it's theoretically possible that in 1979 somebody stripped all of the paint off that house and replaced it with non-lead based paint. So unless you've had a test, you're theorizing that it has lead based paint. You don't know. You're speculating that it probably would have. So you have no knowledge of lead based paint unless you've had a test done. So why would you necessarily have to say, I know for sure there's lead based paint?
Yeah, unless the owner lived there for many, many years, like family generation to generation. You're right, David. If you saying that they know that there's lead paint, but if you are not aware, then check box number 2. Only if somebody, let's say they lived there for hundreds of years and like they're like, we never touched it and there's definitely lead paint, then yes. Then you say you have knowledge.
Okay.
I mean, no knowledge. Okay.
Thanks.
You're welcome. Robert, does that confuse the answer I gave you before, or that makes sense?
Edona, I have a question.
Yes.
You said that every 2 years we have to do the lead test, right? Lead paint. But if the test is done once and they know the test has been done, there is no lead paint, how come in 2 years then again we need to do the test? Because nowadays paint doesn't have lead on it.
Because if the house was built before 1978, they want that inspection done. Now, the owner can choose to pay the more costly inspection where they do a one-time inspection. I believe, like, I don't want to, don't quote me on it, but I remember one inspector said it could be 5,000-6,000 a room to get it where you get it done one time, and then you won't have to do it again. Otherwise, you have to do it every 2 years.
Okay.
And if
So
you
we
have a
can-
tenant that you move in like next week and then they live there more than 2 years, does the landlord have to go back on his own, even though he's not renting to somebody new, to update it?
As per the law, yes. Every 2 years, and if you have like a long-term tenant, let's say they stay there like 4 or 5 years, I would say don't do it, just leave it. But if you have a turnover, then technically by law, I'm just gonna say you have to do the inspection every 2 years.
No, I'm just saying the same tenant, my client asked me, I'm going to put somebody new in there starting September 1. They stay more than 2 years. Do they have to, because I'm not involved in it, go back to the town and re-inspect it? Absolutely, because the tenant's going on to the 3rd year, let's say, or to just leave it alone.
This is from New Jersey website. All rental dwellings units are required to be inspected for lead paint within 2 years of the effective date of July 22nd or upon tenant turnover, whichever is earlier. This means that the first inspection must take place. So I'm going to send you these two links. You can share it with your clients and then let them decide, right? You have to tell them, hey, it's every 2 years or every tenant turnover. And then if they question more, we're not attorneys, okay? So just give them the website, have them read it as well.
Okay, thank you.
You're welcome. So here on the lease, the rental, as you guys are aware, the lease have been updated this year. So now it does include the paragraph for rental dwelling inspections. So please make sure you are abiding by this. Make sure you tell your landlords to do those inspections. And if you're representing the tenant, make sure you also obtain the certification from the listing agent. And if you see the paragraph, it says the law imposes an obligation on municipalities to perform or hire or allow the property owner or landlord to directly hire a certified lead evaluation contractor to perform the inspection of a single family, 2-family, or multiple rental dwellings that are covered by the law for lead paint hazards. So I know somebody said, oh, what if a town doesn't participate? They must abide by the law. All right, so here's the last one for dot loop. I know dot loop looks like a mess because we're going through a major cleanup. So I am working with somebody personally to get it done for you guys. I will be doing a lot of trainings. most likely in the evening, because that works out best for me. They will be recorded. However, we did put all the required documents under all RE/MAX Select documents for the rentals. So all you have to do is create the listing. So rental listing, pick the landlord. All the required documents will be marked required. If it says required, that means it's required. There's no exceptions. The only document that will be an exception is the lead paint, because if you had a property that was built in 2020, then you obviously don't need the lead paint. If it does, please make sure you get that signed when you're sending it to your tenant or landlord. Please include the brochure. Don't just send the lead paint. We mark the brochure as optional, and I just trust that you guys are sharing that with your clients. And then when you prepare a lease, pick tenant, and all the required documents will be marked required. Secure the landlord flood risk notice, the tenant, and lead paint disclosure from listing agent. Add them to your loop and prepare all documents. And then again, lead paint booklet must be provided to landlord and tenant. This also applies to sales and purchases as well. Please make sure that you are sharing the brochure. I am trying to make this so much easier for you guys to address dot loop, because it's been a mess and we are going through that cleanup. Any questions that I have not answered before we end the call? Let me see the chat. Ron, thank you for sharing the exceptions. If you guys look on the chat, he shared the link. You guys should save that. Glenn, I sent mine to towns. Yep, so that's perfect. Does the flood document also pertain to high-rise buildings or only residential homes? Again, I shared the link. Just please look into it. Most high-rise buildings already get the certification, but the flood risk, even if it's a high-rise, it's a law, get it signed. They can check mark no, have it signed, have it on your loop. Yes, I will share.
You still need it. I was on a
Yeah.
state call. I just want to add that, due to the parking areas, because people do park in areas that could be prone to flooding, and they have a right to know that to protect their vehicles, that it is required for common areas as well.
Thank you, Rebecca. Yeah, so just get it signed. This is recorded. You guys will receive a copy. What is the correct documentation for service dog, especially emotional support dogs? Robert, can you just elaborate on that question? Obviously, if it's a service dog, they need to have the documentation from a physician, right? Because you do have somebody who can go online and purchase an emotional support. That's different. Service dog, emotional support, they're kind of different, okay? So again, case by case. So when you come across that, just reach out to your broker. Any other questions? So please just make sure, I know you guys are doing a lot of rentals. Just please make sure that you are abiding by the law. And yes, we want to be there for our clients and help them pick the best tenant. Just we have to also make sure that we are following the new laws. I think there's more questions. I have a landlord who prepares his own lease. Can I add flood, lead components, etc., to that instead of using the standard lease? No, we are not attorneys, so do not add clauses. We cannot change any terms. We have to use the forms that are pre-printed, okay? And I'm glad you asked that question, because I just want you guys to know, if a landlord says, hey, Glenn, I want you to use these, I want the following on my lease, have that in the email, save it, and then you can add it and have them initial it. We cannot, I'm guilty as well. I would write terms like, oh, if a tenant is late 1 month, the landlord has the right to file for an eviction and have the tenant pay all the legal fees. I'm not an attorney. I cannot write that. I came up with that thinking I'm protecting my own client. So don't do that. If a landlord wants specific languages to the additional provisions, have them write it, copy and paste it, add it to the lease. Does that answer your question, Jim?
Wait, are you saying that they have to use our lease and then have them, not their lease, and anything
They
they
can
want
prepare
added?
their own lease, but you can't add the provisions to their own lease. You need to provide them with the actual forms that we have. So they can prepare, if a landlord has their own lease, that's fine. They can fill it out. We can't. We need to use the standard lease that we have in the system. But if they're using you as their agent to do all the other, verification, you need to include these forms. You can't just add them to their lease, like meaning copy and paste. Any other questions? Marnelli, I just want to make sure that you were able to get everybody checked in. If you did not write your name, please do. It's not a test. We're just sending out a survey just to see if you guys were able to understand the material that we went over. If you are signed in with a first name or iPhone, or initials, please make sure you're writing your full name. That's the only way we're going to be able to find you. So I'll just give you guys a second, because if I end the chat, we won't be able to collect that. So I'll just give you guys a second. Just so you guys know, I sent out an email to my offices, but I asked the manager to share it with you tonight, 5 to 8, and Thursday, 5 to 8. I'm doing a training on all the new documents. I know we need a little bit more practice on writing the buyer agency, the new listing forms, the tenant agency. So if you guys need a little bit more help, or if you just want to listen in, tonight on this link that you guys went on this morning, 5 to 8 tonight, and on Thursday. So if you guys need more help, this is the opportunity. We're all in this together. And if you guys don't have any other questions, we'll end now.
You don't know, will this be recorded, put up on YouTube?
This is recorded. We will share the link. We have a new hub. I don't know if you guys were able to go to our new hub, and it will be there on Tuesday Mastermind.
Hi, can you please go over window verification, the window guard?
The window guard. So I don't have a slide for that. That's also like optional, right? So if you have children, you're gonna need the window guards. The landlord is required to get that done.
On the first floor or second floor? The both floor.
Depending how high is the first level. So I would send you, I think you are in Franklin Lakes. Fran Blakely would be the best person. I can also send you guys more information. So it depends, because sometimes first level is really on the second level, right? Definitely second level.
Understood. Thank you so much.
All right, guys, I'm gonna stop the chat.